Please be seated. The sitting is open. The court meets this afternoon to hear the second round of oral argument of Ukraine. For reasons duly made known to me, Vice President Gevorgyan and Judge Joan E are unable to sit with us this afternoon. I now give the floor to Professor Harold Honju-Ko. You have the floor, Professor.
Madam President, members of the court, I'm again honored to appear before you on behalf of Ukraine. As this hearing comes to a close, let us together take stock of where we are. 19 months ago, Ukraine brought you this case after Russia launched a full-scale invasion of Ukraine that continues today in a breathtaking display of aggression, atrocity, and war crimes. Russia made clear its goals for this military action: to stop an alleged genocide and to bring the persons committing that genocide to trial. Russia took this and other actions, citing many official claims that Ukraine was committing violations of the 1948 Genocide Convention. So the basis of Russia's action was unmistakable, that Ukraine and its officials were committing a genocide that Russia was required to take actions to prevent and punish under Articles 1 and 4 of the Genocide Convention. Ukraine immediately and strenuously denied Russia's allegations, charging that Russia had not assessed that a serious risk of genocide exists, and that Russia had systematically abused the convention by taking multiple unilateral actions, recognizing sham republics in Donetsk and Luhansk, invading throughout Ukraine, brutalizing its citizens, and devastating its homeland, all for the stated purpose of preventing and punishing a non-existent genocide. So from the start, as Mavramatis requires, there has been a sharp disagreement on a point of law or fact, a conflict of legal views or of interests over which this court may exercise jurisdiction. Let me first review why a dispute undeniably exists that confers Article 9 jurisdiction on this court, and second, reject Russia's distorted legal theory, which argues that this court may not rule on the merits because of Russia's use of force. After the provisional measures hearing last March, you found that the difference between the parties' position on facts and law were sufficient at this stage to establish prima facie the existence of a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention, and that jurisdiction pursuant to Article 9. Russia's self-serving evasions throughout this hearing only confirm your initial understanding of this dispute. Even as Russia's bombs rain down on Ukraine and its people, Russia continues brazenly to deny your jurisdiction and ignore your provisional measures order. Russia claims that there is no legal dispute between these parties, but these proceedings have shown why this is nonsense. My initial presentation described 4 textual features that define Article 9's distinctively broad scope. First, Article 9 broadly specifies that any of the parties to a dispute under the Convention may submit it to the court. As stated by 5 members of the court in DRC versus Rwanda, under the Genocide Convention, it is states who are the monitors of each other's compliance. So last Wednesday, a landmark day in this court's history, 32 intervening states who agreed to be bound by your judgment explained in a strong and unified voice why the dispute before you raises a question of interpretation, application, or fulfillment of the Convention that this court must decide under Article 9. Russia's counsel tried to dismiss these interventions as puppeting and sheep-like behavior that perverted Article 63 of the court's statute. In fact, the unanimity of these interventions reflects not a dark conspiracy, as Russia claims, but a generality of the opinion which appears to have been cherished by states parties to the Convention regarding its proper interpretation. There is a better explanation than conspiracy as to why 32 states have intervened to confirm Ukraine's legal interpretation, and none have intervened to confirm Russia's. Russia's extreme conduct in Ukraine has so gravely abused the Genocide Convention that no other contracting state will endorse Russia's offensive theory. In granting 32 of these interventions as of right, this court not only rejected Russia's absurd abuse of process claim, but also encouraged joint declarations and oral pleadings, recognizing there is nothing conspiratorial about law-abiding states talking to one another to coordinate common legal positions. These interventions graphically illustrate why, in addition to resolving this contentious dispute, your decision here will help to define the scope of this court's power to stop the flagrant abuse of the world's most important human rights treaty. Second, as the joint separate opinion in DRC versus Rwanda underscored, Article 9 speaks not only of disputes over the interpretation and application of the Convention, but over the fulfillment of the Convention. Russia would have you treat the word fulfillment as surplusage, and thereby rewrite Article 9 to strike out that critical word. But as long as fulfillment is there, the principle of effet utile requires that the term be given distinct meaning independent of the clause's other terms. Indeed, in your own provisional measures order in this case, you expressly noted that direct disagreement between the two parties gives you prima facie jurisdiction to decide whether the use of force by the Russian Federation for the stated purpose of preventing and punishing alleged genocide is a measure that can be taken in fulfillment of the obligation to prevent and punish genocide contained in Article 1 of the Convention. Russia's counsel falsely insisted that the term adds nothing, he said. But as my initial remarks explained, adding fulfillment, defined as accomplishment, performance, or completion of treaty obligations, or in French, execution, as that term is used in Article 26, the good faith provision of the Vienna Convention on the Law of Treaties, codifies Russia's duty to perform, execute, and fulfill its treaty obligations with due diligence and in good faith. Adding fulfillment ensures that the court can review not just whether Russia as a contracting party has violated particular articles of the Convention, but also whether it has performed in good faith its treaty obligations, or instead misused or abused its rights or the Convention as a whole. Third, Russia has also created a dispute about interpretation because the parties strenuously disagree about the meaning of their respective legal rights and obligations under the Convention. Fourth, Ukraine and the 32 intervening states established that this dispute raises questions of application. As you noted last March, there is clear divergence of views as to whether certain acts allegedly committed by Ukraine in the Luhansk and Donetsk region amount to genocide that Russia became obliged to prevent and punish. As the Gabčíkovo-Nagymaros case stated, the principle of good faith obliges the parties to apply a treaty in a reasonable way and in such a manner that its purpose can be realized. By abusing the text and purpose of the treaty to make false allegations, conduct sham recognitions, and launch unlawful military invasions, Russia misapplied the Convention. In the words of Chorzo Factory, creating a situation contrary to Articles 1 and 4. This case thus falls within what the court in Bosnian genocide called the unusual feature of Article 9, a broader group of disputes relating to Russia's responsibility for fulfilling its obligations under the Convention. Everyone, including Russia, agrees that a state that levels allegations of genocide against another can ask the court to resolve that dispute as relating to state responsibility for genocide under the Convention. But if so too must a state like Ukraine be able to resolve an issue relating to state responsibility for genocide by disputing pretextual allegations of genocide and illegal actions taken on the basis of those false allegations. Ukraine and the intervening states all further agree that Article 9's distinctively broad scope reflects both the erga omnes character of the Convention's obligations and the Convention's historic object and purpose. This court famously pronounced more than 70 years ago that the Convention was adopted for a purely humanitarian and civilizing purpose. Granting this court broad Article 9 jurisdiction helps to achieve that object and purpose. States offend the Convention's object and purpose when they ignore a genocide that is clearly occurring. But they also offend that object and purpose when they falsely allege a genocide that is clearly not occurring in order to seek license to illegally attack and invade an innocent neighbor. On Monday, Mr. Udovichenko presented a map of Ukraine's legal position that purportedly showed the vagueness of Ukraine's theory of Article 9 jurisdiction. Instead, what his chart well illustrated was the widely agreed upon breadth of Article 9 in 5-column headings that happened to track the wording of Article 9: abused, violated, misused, misapplied, and misinterpreted. As his chart showed, this court has Article 9 jurisdiction not just when Russia has 1, violated, or 2, abused Articles 1 and 4 of the Convention, but also when Russia has 3, misinterpreted, 4, misapplied, and 5, not fulfilled, misused the Convention. Ukraine's claim regarding Russia's failure of good performance is plainly related to fulfillment. The requirement that Articles 1 and 4 be applied reasonably and good faith is connected with, that is, related to, application. To exercise jurisdiction, that's all you must find. So the jurisdictional question here is simple. Does the necessary relationship exist between the dispute Ukraine brings over Russia's failure to fulfill its obligations to prevent and punish genocide in good faith and interpretation, application, or fulfillment of the Convention? The answer is yes. For that reason, as you'll hear more from Mr. Zients, Russia has entirely fabricated its contention that requests for a declaration of non-violation are alien to the Convention and to international law in general. As Cyprus put it last week, a state falsely accused of genocide must be afforded the opportunity to clear its name, especially when an allegation of genocide is relied upon to resort to armed force. Mr. Udovichenko mocked this assertion as a laughable reputational interest. But as both Lithuania and Cyprus explained, the capacity to bring such claims is an existential necessity for small states who are at risk of unlawful pretextual invasion. As Cyprus explained, it is crucial for these countries that provisions in treaties are not left to the own appraisal of any state party in order to justify the use of force against other states, but are properly construed by the states and ultimately by this court. In Nicaragua v. U.S., the court similarly explained that while the respondent might form its own appraisal of the situation as to respect for human rights in the applicant state, the use of force could not be the appropriate method to monitor or ensure such respect. To prevent such unilateral appraisals from becoming entirely self-judging, Article 9 must be read to empower this court to review state claims of unilateral power to assess and to use force to prevent and punish a perceived genocide. Madam President, members of the court, Russia's counsel have offered a mechanical legal theory arguing that this court may not rule on the merits because of 3 fabricated either-or propositions relating to jurisdiction, breach, and potential application of other rules of international law. Their theory distorts the text, history, object and purpose and jurisprudence of the Genocide Convention. First, Russia has repeatedly insisted the jurisdiction is precluded here because the case Ukraine brings before you is not really about Russia's abuse of the Genocide Convention, but about the legality of Russia's use of force under the UN Charter and customary international law. But in demanding that a dispute must either concern the use of force or the Genocide Convention, Russia sets up a false dichotomy. The court's jurisdiction covers Russia's use of force in this context precisely because Russia used force as a chosen measure to execute its stated goal of preventing and punishing genocide. The court has regularly rejected similar claims by other respondents that a relationship between use of force issues and the applicant's claims brings a case outside the scope of the relevant treaty. In those cases, this court has appropriately rejected Russia's untenable position that the coexistence of use of force issues somehow renders a claim per se inadmissible. Instead, the court has carefully evaluated, as you should do again here, whether a dispute exists under the treaty at issue over which you have jurisdiction, regardless of any role that the respondent's use of force might play in the ultimate resolution of the case. In oil platforms, the court rejected the preliminary objection of a P5 member of the Security Council that the applicant's claims fell outside the relevant compromissory clause because essentially the dispute relates to the lawfulness of actions by naval forces that involve combat operations. The court held that a violation of the rights of one party under the treaty by means of the use of force is as unlawful as would be a violation by administrative decision or by any other means. Matters relating to the use of force are therefore not per se excluded from the reach of the treaty. Here as well, connection to use of force issues creates no per se exclusion from the reach of the Genocide Convention. By using force as its measure to prevent and punish genocide, it is Russia that has placed its own use of force within the scope of the Genocide Convention. If any examination of the legality of Russia's use of force were to occur, it should happen at the merits, as it did in oil platforms. More recently, in Georgia versus Russia, this court similarly resisted Russia's attempt to divest the court of jurisdiction because the applicant's claims challenge use of force. Last week, Russia's agent misleadingly claimed that, quote, back in 2011, the court had correctly decided that Georgia's claims rooted in the allegations of use of force did not pertain to racial discrimination. In fact, what the court squarely rejected was Russia's argument that Georgia's evidence of a dispute related to the use of force in Abkhazia and South Ossetia somehow divested the court of jurisdiction over a dispute related to the interpretation and application of the Race Discrimination Convention, the CERD. Instead, the court determined that, quote, while the Georgian claims were primarily about the allegedly unlawful use of force, Georgia had presented sufficient evidence of the existence of a dispute between the parties related to the interpretation or application of the human rights treaty at issue. Similarly, Ukraine's claims here center on Russia's allegations and actions based on another human rights treaty at issue, the Genocide Convention. The mere existence of use of force issues has never created a per se carve-out from this court's jurisdiction or admissibility that overrides the contracting party's consent. Second, Russia's counsel attempted to erect a similarly sharp divide between Russia's breaches of the convention and its duty to perform in good faith, which Russia characterized as only relevant to conduct outside the scope of the convention, whatever that means. Again, this entirely manufactured distinction in no way reflects reality. Mr. Krozato conceded that the Gabčíkovo-Nagymaros duty to act in good faith with respect to a treaty is about performance, or as Article 9 puts it, fulfillment of the treaty's obligations. Given that litigating about fulfillment falls within the express terms of the convention, How can litigating about performance in good faith be an obligation that falls outside the convention? Or take this court's Genocide Convention jurisprudence. The 1999 legality of the use of force case concerned NATO bombing to protect innocent civilians. Russia's agents cited many public statements in April 1999 by various government policymakers, including myself, warning that Serbian leaders were committing acts of genocide. Without evidence, Russia's agent called this a pretext. But Slobodan Milosevic, the president of Serbia, was later indicted by the ICJ for crimes against humanity and for genocide in related conflicts. So that case offers no parallel to Russia's pretextual allegations of genocide without due diligence, which are at issue here. For that reason, we must separate thoughtful legal analysis from the kind of political diatribe we heard from Russia's agent on Monday. As Judge Nolte acknowledged in his separate decision to the provisional measures order in this case, in the legality of use of force case, Judge Nolte wrote, "It is true that in 1999, certain respondent states came close to justifying their use of force by stating that their actions were taken with the intent to prevent genocide and that certain of their officials made allegations of genocide in that context. However, such justifications were not the stated purpose of the military operations by the respondent states, nor was that purpose so perceived by the applicant state. That aspect was therefore not the subject matter of the earlier cases before the court." As a legal matter, Judge Nolte observed, neither the applicant state nor the respondent states stated before the court that use of force by the respondent states had the purpose of preventing an alleged genocide. So, unlike Ukraine, Serbia did not allege that NATO allegations of genocide were pretextual, nor did it invite the court to consider whether it was responsible for genocide. In the present case, by contrast, Judge Nolte noted, Russia has, quote, made allegations that Ukraine is committing genocide and has affirmed that its special military operation serves the purpose of preventing genocide, thereby acting in a way that is capable of coming within the provisions of the Genocide Convention. The Bosnian genocide case also arose in an entirely different posture. This court took jurisdiction under Article 9 after Bosnia and Herzegovina charged Serbia and Montenegro with committing genocide under the Genocide Convention. Mr. Crozato selectively quoted parts of Bosnian genocide to support his either-or claim that a case against a responding state must be brought inside, not outside the convention. But just 2 paragraphs after the language he quoted, in language oddly omitted from his presentation, the Bosnian genocide judgment stated that in order to determine whether the respondent breached its obligation under the convention, the court will have recourse not only to the rules of general international law, not only to the convention itself, but also to the rules of general international law and treaty interpretation, and on responsibility of states for internationally wrongful acts. In short, this court has rejected precisely the mechanical inside-outside distinction that Russia's counsel advocates. Third and finally, there is nothing in this court's jurisprudence barring other sources of international law from being consulted to help determine whether Russia has acted unlawfully to prevent and punish genocide under the convention. In Croatian genocide, the court took jurisdiction under Article 9 and on the merits dismissed both the Croatian claim and Serbian counterclaim on the ground that neither side had provided sufficient evidence of the respondent's specific intent to commit genocide. Mr. Crozato emphasized the court's holding it would not consider a state's liability for war crimes falling short of genocide. But what he admitted was that the court immediately followed with this caveat: that does not prevent the court from considering in its reasoning whether a violation of international humanitarian law or international human rights law has occurred, to the extent that this is relevant for the court's determination of whether or not there has been breach of an obligation under the Genocide Convention. That is the situation here. As Latvia observed last week, the concerns, institutions, and teleology of the Genocide Convention and the rules on the use of force expressed in the UN Charter are closely intertwined. Thus, the Genocide Convention's preamble refers to the spirit and aims of the United Nations, whose charter includes maintaining peace and security, suppressing aggression, reaffirming faith and fundamental human rights, and promoting the peaceful settlement of disputes. As this case proceeds to the merits, the court may be called on, as it was in Croatian genocide, to apply other sources of international law to decide a dispute under the Genocide Convention. But insofar as the Convention and international humanitarian law may be applicable in the context of a particular armed conflict, the rules of international humanitarian law might be relevant in order to decide whether the acts alleged by the parties constitute genocide within the meaning of Article 2 of the Convention. As the United Kingdom noted in its intervention, the scope of other rules of international law that constrain state behavior, conduct permitted by Article 1, is not indefinite or extrinsic to the Convention. Rather, they are embedded within it, consistently with the object and purpose of the Convention. It is unthinkable that a state fulfilling its undertaking to prevent genocide in good faith could do so through aggression or other international crimes. Again, Russia's counsel mocked this final statement, but that only confirms what we have all witnessed on the battlefield these last 19 months. Use of such illegal tools is not unthinkable to Russia. But in due course, as the United Kingdom urged, this court might decide to look to governing jus ad bellum and jus in bello rules to decide whether such Russian use of force measures as aggression, crimes against humanity, or war crimes taken in the name of punishing genocide are ever compatible with the Genocide Convention. But such considerations are for the merits and pose no barrier to this court's jurisdiction to reach that stage. In sum, Russia's mechanical legal theory artificially flattens the issues before you into false dichotomies. This court may take jurisdiction over a dispute that fits under Article 9's various heads of jurisdiction, whether or not it involves use of force, and on the merits may consider other sources of international law to help determine whether Russia's actions, including its use of force, violate its obligations under the Genocide Convention. Madam President, members of the court, on the eve of the 75th anniversary of the historic Genocide Convention, it is time to reaffirm this court's commitment to your crucial role in deciding the real issue before you. May a powerful state falsely accuse its neighbor of genocide, then use illegal force to kill its citizens, devastate their homeland, and destabilize the global legal order, all on the pretext of preventing and punishing genocide. However bloodless and antiseptic Russia's legal theory may appear, Russia is deploying that theory daily and unilaterally to destroy lives and attack the global foundations of human rights law and the rule of international law for which the Genocide Convention stands. The jurisdictional questions before you are neither close nor are they difficult. And while you deliberate, the world awaits a speedy hearing on the merits. Distinguished judges, for these reasons, the court should promptly dismiss Russia's preliminary objections and schedule a hearing on the merits. Madam President, it has been my honor to appear before you. I thank you, and I ask you to call my colleague, Ms. Cheek, to the podium. Thank you.
I thank Professor Coe, and I now give the floor to Ms. Marnie Cheek. You have the floor, madam.
Madam President, members of the court, it is an honor to appear before you again on behalf of Ukraine. This afternoon, I will once again focus on the existence of a dispute between Ukraine and the Russian Federation related to the subject matter of the Genocide Convention. In its second round of oral pleadings, Russia argues that this court should ignore statement after statement made by senior Russian officials referencing Ukraine's alleged commission of genocide. It argues that its reliance on genocide to justify its recognition of the so-called DPR and LPR and its full-scale invasion of Ukraine is simply rhetoric. At the same time, it has no answer for why its officials, including the Deputy Chairman of the Security Council, have referred to the Genocide Convention by name when justifying Russia's actions. Russia instead asked this court to find that Article 51 of the UN Charter was the sole justification for its actions in and against Ukraine. Russia asks you to disregard the words of its president, clearly stating that the purpose of Russia's so-called special military operation was to stop genocide. Instead, Russia invites you to rely on Russia's bare invocation of Article 51 in a letter transmitted to the United Nations on the 24th of February, 2022, even though the same letter attaches President Putin's speech that declares the purpose of Russia's actions against Ukraine to be genocide prevention. In the alternative, Russia argued for the first time in these oral hearings that even if a dispute regarding the subject matter of the convention existed at the time of Ukraine's application, no such dispute exists today, and so Ukraine's claims are devoid of object and should be dismissed. Having heard Russia's rebuttal on Monday, it remains the case that an objective examination of the facts shows that at the time Ukraine filed its application with this court, the parties had a dispute related to the interpretation, application, or fulfillment of the Genocide Convention. My presentation this afternoon will proceed in three parts. First, I will demonstrate that on the current record before the court, there exists a dispute between the parties relating to the interpretation, application, or fulfillment of the Genocide Convention at the time Ukraine filed its application. Second, I will explain how Russia's letter to the UN Secretary General regarding its purported exercise of the right to self-defense under Article 51 of the UN Charter does not negate the parties' dispute with regards to the Genocide Convention, but rather affirms it. Finally, I will address Russia's new argument that Ukraine's claims are without object because Russia has asserted in these oral proceedings that it agrees with certain of Ukraine's interpretations of the Convention. What should the court make of Russia's repeated references to genocide? In the words of Professor Azari, quote, regarding the statements of Russian politicians who use the term genocide, it must be recognized that the simple reference to this term is insufficient to establish the existence of a dispute under the Genocide Convention, end quote. But this court should not disregard Russia's statements alleging that Ukraine was committing genocide. Russia cannot credibly claim that its long-standing allegations of genocide against Ukraine and its officials were mere rhetoric or simply political. To start, Russia's state organs and officials have, for years, claimed that Ukraine and its officials are committing genocide in violation of the Genocide Convention. As for Russia's investigative committee, not only did it explicitly claim that Ukrainian officials were violating the Genocide Convention, but Russia's domestic criminal code defines genocide in nearly identical terms to the definition in Article 2 of the Genocide Convention. Therefore, when Russia's investigative committee uses the term genocide, it means genocide as that term is defined in the Genocide Convention. Russia has not shown otherwise. On Monday, Russia again tried to dismiss the numerous statements of the investigative committee by insisting that the investigative committee does not speak for Russia at the international level. But Russia's complete failure to engage at all with the content of the statements of the investigative committee is telling. I need not repeat each of the investigative committee statements that I took you to last week, but I include one example here on the screen. As the court will recall, the investigative committee has consistently and explicitly alleged that high-ranking Ukrainian officials have acted in violation of the Genocide Convention. Russia cannot escape this fact, and it does not even try. More telling still, you heard nothing from Russia about the investigative committee's own efforts to publicize the results of its investigations, to use Russia's words, at the international level. These efforts were amplified by Russia's Ministry of Foreign Affairs, which published the investigative committee's English-language book documenting its investigations, including its allegations of genocide against Ukrainian officials. Russia calls it the White Book of Crimes. This book was published on the Foreign Ministry's website within its Foreign Policy section, as you can see in the snapshot of the Russian Foreign Ministry website on the screen. Further, on March 3rd, 2022, just 1 week after Russia's full-scale invasion of Ukraine, the spokesperson for Russia's foreign ministry highlighted its role in publicizing the investigative committee's reports and its conclusions. Regarding the investigative committee's work, she commented, quote, "Do you think we have hidden it in a secret library? Of course not. It's available on the foreign ministry website and social media. We sent it to all our partner countries and international organizations." The investigative committee's consistent allegations that Ukrainian officials were violating the Genocide Convention is plainly evidence of the existence of the parties' dispute. Russia has had every opportunity to tell this court that no, it does not believe, and it never believed, that Ukraine is committing genocide in Donbass in violation of the Genocide Convention, or to somehow explain why its officials repeatedly reference the Genocide Convention specifically, but it has not done so. Russia's arguments on the existence of a dispute suffer from a fatal flaw. Russia cannot escape the facts. Russia has repeatedly advanced allegations of genocide against Ukraine and has expressly claimed that Ukraine and its officials are violating the Genocide Convention. Russia has taken action against Ukraine on the explicit basis of preventing and punishing that alleged genocide. Russia also has made various attempts to discount evidence that Ukraine opposed both Russia's allegations of genocide and Russia's actions taken in and against Ukraine in reliance on those allegations. First, with regard to the statements by Ukrainian officials opposing the genocide allegations of Russia's investigative committee, Russia's only comment on Ukraine's statements, calling Russia's allegations groundless and a complete delusion, was to argue on Monday that because the investigative committee is not acting at the international level, Ukraine's opposition to its accusations of genocide cannot be credited. But I have already disposed of this issue. The investigative committee has leveled inherently international allegations against high-ranking officials of another sovereign state. Russia's foreign ministry promoted those allegations. There is no reason the court cannot consider both the investigative committee's statements and Ukraine's opposition to them as evidence of the parties' dispute. Russia also had little to say about Ukraine's Foreign Minister Kuleba's statement before the UN General Assembly on the 23rd of February, 2 days after Russia had recognized the so-called DPR and LPR in reliance on its false allegations of genocide. Minister Kuleba called Russia's accusations absurd. Professor Azari noted that Minister Kuleba did not mention genocide or the Genocide Convention. But as I noted previously, in context, it is quite reasonable to view Minister Kuleba's remarks as a comment on Russia's view that it had recognized DPR and LPR in order to bring a genocide to Donbass to an end. Second, with regard to conduct, I urge the Court to consider the substance of Ukraine's opposition, since it involved denouncing Russia in the United Nations and fighting Russia's full-scale invasion launched in the name of preventing and punishing genocide. On Monday, Professor Azari invoked this Court's decision in Georgia versus Russia at paragraph 108. He invoked that paragraph in response to Ukraine's conduct agreement, and specifically with regard to Ukraine's actions in its own self-defense. But that paragraph is silent on the relevance of conduct when assessing whether the parties hold opposing views such that a dispute exists regarding the subject matter of the treaty. That paragraph examined a Georgian decree focused on the use of force, rather than the subject matter of that dispute, which was the CERD. It is irrelevant here. As I set out last week, this Court has previously confirmed that the conduct of the parties may be relevant to its assessment of whether or not a dispute exists, particularly in cases where, for various reasons, there have been no diplomatic exchanges between the parties. That consideration is quite relevant in this case. There is further evidence of the parties' opposed viewpoints. Russia criticizes the statement of the Ministry of Foreign Affairs published on the 26th of February, 2022. On Monday, Russia's counsel went as far as to accuse Ukraine's foreign ministry of, quote, fabricating evidence. Ukraine objects to that in the strongest terms. As stated previously, the 26th February statement confirmed that a dispute between the parties had already crystallized. In any case, Russia's principal point seems to be that even if it was aware of the statement, it did not have time to react to it. In the context of this case and the urgency of the situation when this case was filed, not to mention the language of the compromissory clause of the Genocide Convention, which requires no consultation prior to seizing the court, Russia's argument does nothing to detract from the conclusion that Ukraine and the Russian Federation held opposing views on the subject matter of the Genocide Convention at the time Ukraine filed its application with this court. Further, as a factual matter, the statement was published on the website of the Ministry of Foreign Affairs, across its social media channels, and shortly thereafter on the official Ukrainian government portal. The parties are agreed that this statement was issued prior to Ukraine filing its application. On Monday, Russia's counsel relied on Marshall Islands versus the United Kingdom in an attempt to undermine the significance of this 26th of February statement. But the statements in Marshall Islands of the applicant lacked specificity and were hortatory in nature. The factual distinction between that case and the case before you here is readily apparent. In the present case, Russia made explicit and direct allegations that Ukraine and its officials were committing genocide. Russia was aware, or it could not have been unaware, that Ukraine opposed those allegations. Yet in February 2022, rather than remedying this disagreement and withdrawing its allegations of genocide against Ukraine, Russia took action on the stated basis of bringing an alleged genocide to an end, Ukraine forcefully opposed those actions. Despite Russia's continued insistence, the objective question of whether the parties hold opposite views with respect to the subject matter of the treaty does not turn on whether the respondent expressly and explicitly opposed the claims of the applicant state. The court made this clear in the Gambia versus Myanmar, adding that, quote, "If that were the case, a respondent could prevent a finding that a dispute exists by remaining silent in the face of an applicant's legal claims. Such a consequence would be unacceptable." Professor Azari is not correct when he insists that Ukraine must prove, quote, "that before the filing of the application, it claimed a violation of the 1948 Convention and that its claim was manifestly opposed by the Russian Federation." The court could not have been clearer in Nicaragua versus Colombia, quote, "It does not matter which one of them advances a claim and which one opposes it. What matters is that the two sides hold clearly opposite views concerning the questions of the performance or non-performance of certain international obligations." I also take note of Judge Crawford's dissent in Marshall Islands, where he stated that, quote, "Egregious conduct can create a dispute ipso facto without the need for a letter before action or other communication," end quote. Russia's invasion of Ukraine on the 24th of February 2022, whose stated purpose was to stop a genocide in Donbass and punish the perpetrators, is a stark example of such egregious conduct. Russia's allegations and the actions it has taken in purported reliance on those allegations plainly fall within the subject matter of the Genocide Convention, namely genocide and the prevention and punishment thereof. Ukraine has opposed these allegations and the actions Russia has taken in reliance on those allegations, and Ukraine did so before filing its application. Consistent with the court's well-established standards, this is sufficient to establish the. This court found at the provisional measures stage that the evidence demonstrated prima facie the existence of the parties' dispute. Russia has presented no evidence since the court's order that undermines that prima facie conclusion. On the other hand, Ukraine has supplemented the record with additional evidence that confirms that by the time of Ukraine's application, there was a dispute between the parties related to the Genocide Convention. Russia thus turns to Article 51 of the UN Charter. According to Russia's counsel, Professor Yi, quote, "The rights and obligations of the parties surrounding the special military operation or Russia's recognition of the DPR and LPR arise under the right of self-defense under Article 51 of the UN Charter and relevant customary international law over which the court has no jurisdiction," end quote. But it is this court's role, not Russia's, to objectively characterize the specific dispute brought to it by Ukraine. Objectively, that dispute relates to Russia's actions for the stated purpose of preventing and punishing genocide, a subject governed by the Genocide Convention. One piece of evidence of that dispute, as Russia notes, is its one-paragraph letter from Russia to the Secretary General of the United Nations, which refers to Article 51 of the UN Charter and attaches President Putin's speech of the 24th of February 2022. That cover note is devoid of reasoning. But the speech of Russia's president, transmitted to the United Nations as an annex, expressly declares that the purpose of the so-called special military operation is to, quote, "stop a genocide." That is the key jurisdictional fact. Russia cannot avoid it by hiding behind references to Article 51. We heard many references to Article 51 on Monday, but I encourage the court to look at the short letter from Mr. Nebenzia to the Secretary General that Russia on Monday called decisive. This is the language in its entirety on the screen. It identifies no armed attack. It specifies no particular measure as being proportionate and necessary to respond to an armed attack. The letter simply refers to an annex, that annex being President Putin's address of the 24th of February, 2022. Russia, like other states, has in other circumstances made reports to the Secretary General or the Security Council under Article 51. Russia did so in 2008 following its use of force in Georgia. In that report, Russia set out expressly its basis for acting in self-defense. And that report is on your screen. It asserted, quote, "The use of force by the Russian side is strictly proportionate to the scale of the attack and pursues no other goal but to protect the Russian peacekeeping contingent and citizens of the Russian Federation from the illegal actions of the Georgian side and to prevent further attacks against them." These two letters to the United Nations are quite different. It is striking that when Russia claimed self-defense in Georgia, it identified a specific alleged armed attack by Georgia. It defended the proportionate nature of its defensive actions in response, and it stressed that Russia's military acted and their actions pursued no other goal than self-defense. Russia's 2022 letter to the United Nations with respect to Ukraine does nothing of the sort. Of course, at this stage of the proceedings, the court does not need to examine the merits of Russia's assertion that its reference to Article 51 of the UN Charter shields it from liability under the Genocide Convention. But for the purposes of jurisdiction, this letter is relevant and that it shows that the only justification provided by the Russian Federation for its full-scale invasion of Ukraine was a purported genocide occurring in Donbass. Russia's 2022 letter simply incorporates President Putin's 24 November speech, which makes abundantly clear that Russia was not limiting itself to purely defensive purposes and goals. To the contrary, President Putin's speech explains that the so-called special military operation had one purpose. Quote, "The purpose of this operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kiev regime." President Putin said that to this end, Russia would take measures to denazify Ukraine and, quote, "to bring to trial those who perpetrated numerous bloody crimes against civilians." Thus, as Judge Robinson observed, President Putin's speech, quote, "makes clear that notwithstanding the possible defensive aims of the special military operation, the operation had a clear protective aim. More specifically, it aims to protect against alleged acts of genocide committed by Ukraine, which Russia considered to be contrary to Ukraine's obligations under the Genocide Convention," end quote. Mr. Nebenzia's cover letter mentioning Article 51 of the UN Charter does not cancel out President Putin's stated purpose for Russia's actions in Ukraine. To the contrary, the letter incorporates President Putin's stated purpose. And President Putin's statement is the only substantive explanation provided by the Russian Federation to the United Nations for Russia's actions. In view of the unusual nature of Russia's letter to the Secretary General, it's doubtful whether it qualifies in either form or substance as the report to the Secretary General required by Article 51 for all measures taken in self-defense. But the fundamental point at this stage of the proceedings is that Russia's reference to Article 51 of the UN Charter does not mean that a dispute does not exist between the parties relating to genocide. The Court has consistently recognized, as it did recently in the alleged violations case, that, quote, certain acts may fall within the ambit of more than one instrument, and a dispute relating to those acts may relate to the interpretation or application of more than one treaty or other instrument. Even if Russia claims its actions fall within Article 51 of the UN Charter, that does not exclude the same actions from also falling within the scope of the Genocide Convention. Ukraine's application pertains to the parties' dispute under the Genocide Convention. As the Court went on to note in alleged violations, it, quote, cannot infer the subject matter of a dispute from the political context in which the proceedings have been instituted, rather than basing itself on what the applicant has requested of it. As Professor Coe mentioned earlier, this is also not the first time the Court has been presented with a dispute involving the use of force and assertions of a right of self-defense. In oil platforms, the Court determined that it had jurisdiction over whether the use of force breached the Treaty of Amity, even though the United States had not consented to the Court's jurisdiction over use of force disputes more generally. In deciding whether the United States breached the Treaty of Amity, the Court considered that the United States' claims of self-defense was not an automatic exclusion from jurisdiction, but a defense on the merits. Here, assuming for the sake of argument that there is a dispute between the parties as to whether Russia's use of force was permitted under Article 51 of the UN Charter, there is also a dispute between the parties under the Genocide Convention. That dispute relates to whether Russia's actions in and against Ukraine for the stated purpose of stopping and punishing a genocide violates Articles 1 and 4 of the Genocide Convention. In other words, Russia's reference to the right of self-defense under the UN Charter does not redefine the dispute that Ukraine has brought to this Court, nor does it negate the existence of a dispute relating to the Genocide Convention. The Court already considered Russia's reference to Article 51 and made this fundamental point at paragraph 46 of its Provisional Measures Order. There is no reason to reach a different conclusion now. There is another way to frame this question, but the outcome is the same. Namely, the Genocide Convention governs the prevention and punishment of genocide, whether through the use of force or other measures. Russia has acted for the stated purpose of bringing a genocide to an end and punishing its perpetrators. That action, for that stated purpose, falls squarely within the subject matter of the Genocide Convention. Ukraine contends that under the Convention, Russia has committed to certain undertakings pertaining to the prevention and punishment of genocide. Russia has committed to act to prevent and punish genocide in good faith, without abuse, and within the limits of international law. Ukraine claims that Russia has acted for the stated purpose of preventing and punishing genocide, but did so not in good faith. It did so abusively and beyond the limits of international law. By acting in contravention of the undertakings it made under the Genocide Convention, Ukraine claims Russia violated the Convention. Whether or not Ukraine and Russia also have a dispute that relates to the UN Charter, the Court may assert jurisdiction over the dispute brought by Ukraine under the treaty signed by both parties that governs the prevention and punishment of the crime of genocide. Finally, I note that Russia's discussion of self-defense is not relevant to Ukraine's claim that Russia violated the Genocide Convention in connection with its recognition of the so-called DPR and LPR. Russia's permanent representative to the United Nations justified Russia's recognition of the so-called DPR and LPR by claiming that, quote, in the light of the blatant genocide, Russia could no longer remain indifferent to the fate of the 4 million people of the Donbass, end quote. In this court, Russia has suggested that its recognition of the so-called DPR and LPR related to customary international law principles of self-determination, but that justification was not clearly presented at the time. In any case, the analysis remains the same. Even if the parties also have a dispute over whether Russia's act of recognition has a basis in some other principle of international law, there is also a dispute concerning Russia's recognition of the so-called LPR and DPR as a measure to prevent and punish a genocide. That dispute relates to the interpretation, application, or fulfillment of the Genocide Convention. As such, it is within this court's jurisdiction, whatever else Russia may wish to say about it on the merits. The last topic I will address this afternoon is Russia's new argument against jurisdiction, pled for the first time in these oral pleadings. Russia asserts that regardless of whether there was a dispute at the time Ukraine filed its application, there is no live dispute now. Professor Yi relies on the court's recent judgment in Chile versus Bolivia on this point, where the court stated with regards to the parties' dispute relating to the waters of the Salala, quote, if the court finds that the parties have come to agree in substance regarding a claim or a counterclaim, it will take note of that agreement in its judgment and conclude that such a claim or counterclaim has become without object. In such a case, there is no call for a declaratory judgment. Neither Chile versus Bolivia nor any of the other cases Professor Yi cited applies to the situation before this court. Russia identified two purported points of agreement between itself and Ukraine. First, Russia says that it agrees that, quote, it has an obligation to perform its obligations under the convention in good faith. Second, Russia says that it agrees that, quote, the Genocide Convention does not authorize, confer a right, or impose an obligation to use force to prevent or punish genocide, end quote. But the alleged agreement between the parties on these 2 points of law does not come close to establishing that the parties have come to agree on the substance regarding a claim. First, Russia's purported agreement that it must perform its obligations in good faith does not resolve any claim. Ukraine alleges that Russia has not performed its obligations under Articles 1 and 4 of the Genocide Convention in good faith. Nowhere has Russia agreed with that claim. Put differently, even if Ukraine and Russia agree on the interpretation of this aspect of the convention, they do not agree on its application and fulfillment. That dispute still exists. Second, Russia's statement that the Genocide Convention does not authorize, confer a right, or impose an obligation to use force to prevent or punish genocide is not the only question before this court, and it has not been put to this court in the abstract. Ukraine claims that Russia has abused Articles 1 and 4 of the Convention by taking unilateral action in and against Ukraine based on false allegations of genocide. In that regard, Ukraine asks this court to find that Russia's, quote, use of force in and against Ukraine beginning on the 24th of February 2022 violates Articles 1 and 4 of the Convention, among Ukraine's other submissions. Nowhere has Russia agreed that it used force in violation of the Genocide Convention. There is no agreement on the application, fulfillment, or even the interpretation of the Convention on that point. Ukraine's claims have not become without object. Nuclear tests is of no assistance to Russia either. There, the court relied on a legally binding undertaking by France's president. That undertaking committed France to the precise and complete relief that Australia and New Zealand sought before this court. Nothing of the sort has happened here. To quote Professor Yi, quote, "The key rule is that at the time of adjudication, there must be a live dispute between the parties for the court to proceed," end quote. Ukraine agrees, and this is a live dispute indeed. Russia has not agreed to a single one of Ukraine's submissions. Simply put, a dispute exists between the parties related to the subject matter of the Convention. Madam President, members of the Court, let me offer a few concluding remarks. Russia's argument that the object of the dispute has disappeared is a variation on Russia's theme. It believes that it can say one thing in the Great Hall of Justice and quite another thing outside of this courtroom. While Russia has argued here that there is no real dispute between the parties and that it took action in and against Ukraine for solely defensive purposes, its leadership has told the international community another story. Outside of this courtroom, senior Russian officials and President Putin himself have fastidiously stuck to Russia's genocide rationale, first articulated by President Putin in February 2022. The sole purpose President Putin identified for Russia's so-called special military operation was to prevent and punish a purported genocide in Donbass. To this end, he said, Russia announced the objectives of denazifying Ukraine and bringing to trial those who perpetrated numerous bloody crimes. At a briefing of the UN Security Council, Russia's representative announced that the goal was to stop genocide. Russia says in this great hall that its leadership did not invoke the Genocide Convention by name. It says that genocide is just used by Russia, indeed by all countries, as political rhetoric. But Russia's statements and actions outside of this courtroom tell another story. Russia did not just use the word genocide, it acted on those words. It engaged in a full-scale invasion on the pretext of stopping a genocide. Outside of this courtroom, Russian officials did invoke the Genocide Convention by name. The convention was relied upon by Russia's investigative committee. It was referenced by Foreign Minister Lavrov in 2020. It was highlighted 2 weeks ago by Dmitry Medvedev, the deputy chairman of Russia's Security Council. Russia stands before you in this great hall and ignores this evidence. On Monday, Russia did not deny or contradict Medvedev's statement. It did not tell you that its foreign ministry routinely relies on its investigative committee and that its allegations of genocide are published at the international level. It never explained why this court should ignore the purpose and goal of Russia's use of force as stated by its president and communicated to the United Nations. While Russia will say many things in this great hall of justice, it did not contradict its president. It did not denounce its foreign minister or discredit the deputy chairman of its Security Council. I urge this court to look at the evidence in the record and not just the words uttered in this courtroom. The evidence before you demonstrates that a dispute exists between these parties related to the interpretation, application, or fulfillment of the Genocide Convention. Russia's first preliminary objection should therefore be rejected. Thank you, Madam President, members of the Court. I now ask that you call upon Professor Jean-Marc Touvenin.
I thank Ms. Cheek, and I now invite Professor Jean-Marc Touvenin to address the Court. You have the floor, Professor.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam President. Madam President, distinguished members of the Court, I come before you one last time to address the issue of your jurisdiction ratione materia, as you may consider it at this stage of the proceedings. On Monday, Russia showered you with approximations. It tried to turn Ukraine's claims into something they are not, and indeed admitted quite openly to distorting the terms of those claims. I'll repeat it because I really mean that, to distorting the terms of these claims by making questionable inferences, and in a show of false naivety, it tried to convince you there are contradictions where there aren't any, with question marks galore. Rather than helping the Court to do its duty, our friends opposite strived to make. This is one of Russia's well-worn tactics. The smoke, however, the smoke screens constructed by our learned friends began to blow away as soon as they appeared. Thus, I will only address 3 points, which are literally obsessing the other side, before coming back to the role of good faith, of abuse of right, and of the obligation to act within the limits of international legality in the context of the interpretation, application, or fulfillment of the Convention. Madam President, the first, and indeed mistaken idée fixe or fixation of Russia is that Ukraine's claims concern everything except the Convention. Mr. Crosato, who thought it was relevant to respond to what is only an illusion, claimed that the compromissory clause cannot establish your jurisdiction, and I quote him, beyond
disputes regarding alleged breaches of the Convention itself, as Ukraine seems to suggest. Fin de citation.
End of quotation. Clearly, Ukraine has suggested nothing of the sort. The dispute it has brought before you concerns exclusively breaches of the Convention and the obligations that arise therefrom. Although he claimed not to, my friend opposite had no other choice to breathe life into his idée fixe than to rewrite Ukraine's claims, something he may not do. But to convince you that it is rewritten claims that should prevail, he put up on the screen the list of reparations sought by Ukraine in its memoria. But of course, the only question that can determine your jurisdiction under the Convention concerns the breaches of international law, which Ukraine is asking the court to establish, not the reparations for harm arising from those breaches. Yet, all the alleged breaches, those alleged by Ukraine in the conclusions of its memorial, fall within the scope of the Convention. As you can see, submissions B, C, and D concern specifically and exclusively breaches of the Convention on the Genocide Convention. Ukraine requests that the court B. A judge and declare that there is no credible evidence that Ukraine is responsible for committing genocide in violation of the Genocide Convention in the Donetsk and Luhansk oblasts of Ukraine. C. to adjudge and declare that the Russian Federation's use of force in and against Ukraine beginning on the 24th of February 2022 violates Articles 1 and 4 of the Genocide Convention. And D, to adjudge and declare that the Russian Federation's recognition of the independence of the so-called Donetsk People's Republic and Luhansk People's Republic on the 21st of February 2022 violates Articles 1 and 4 of the Genocide Convention. End of quotation. There goes Mr. Cruzata's first layer of smokescreen. Contrary to what he tried to hammer home in various manners and ways, Ukraine is only requesting that the court establish that the convention has been breached, nothing else. In fact, I believe that were we to have a third round of oral arguments, this fact might lead to an agreement. My friend opposite did state, indeed, that, and I quote,
Ukraine's suggestion is that Article 9 somehow grants jurisdiction more generally to rule on breaches of obligations not set forth in the obligation itself. The argument must be rejected. Fin de citation.
End of quotation. I have just allayed his fear. That is not what Ukraine is suggesting. The dispute it has brought before the court can therefore be entertained on the merits. Madam President, I take this opportunity to say that, quite obviously, a breach of the Convention may involve a breach of other rules of international law. This is indeed what the court stated in the Croatia versus Serbia case, which Russia misquoted, which is what it often does. In that case, the court stated that the jurisdiction conferred upon it by Article 9, and I quote, does not prevent the court from considering in its reasoning whether a violation of international humanitarian law or international human rights law has occurred, to the extent that this is relevant for the court's determination of whether or not there has been a breach of an obligation under the Genocide Convention. End of quotation. In other words, it is not because the means used to breach the Convention is itself a breach of another rule of international law that that breach of the Convention ceases to exist. This obvious fact wrecks Russia's reasoning, which, upon close scrutiny, really only claims one thing, which is, were a state to order its troops into the territory of another state, to quash its resistance and massacre a whole ethnic group in that territory, the Convention would not apply because, according to the theory hammered home by Mr. Cruzata, and I quote,
does not regulate matters related to the use of force and the recognition of states. Fin de citation.
End of quotation. It's simply untenable. Madam President, I was criticised, or Ukraine was criticised, for not mentioning the court's jurisprudence on Article 9 of the Convention, as if on this side of the aisle we were unwilling to do so. On this side of the aisle. Russia first laid great store by paragraph 431 of the judgment on the merits in the genocide in Bosnia case. It states that, and I quote, a state can be held responsible for breaching the obligation to prevent genocide only if genocide was actually committed. According to Russia, since Ukraine claims that no genocide was committed, there can be no breach of the Convention, and thus the matter is settled. But what Ukraine is saying is that Russia has accused and is accusing Ukraine of committing or allowing a genocide to be committed as a pretext to invoke its obligations and launch actions in and against its territory. So the case is not settled at all. Russia has not withdrawn its genocide allegations, has not recognized it's invoked them only as a pretext to justify acts which are entirely at odds with what the Convention requires, and did not repair the harm caused by its unlawful contact. Quite to the contrary, day after day, Russia continues to undertake actions in Ukraine to prevent this purported genocide and punish the perpetrators thereof. As to the provisional measures orders in the legality of the use of force cases, one of Russia's other leitmotifs, they simply stated, and this is only feasible at the provisional measures stage, by the way, that Serbia and Montenegro's genocide accusation against various countries were not plausible. This is without relevance whatever here, because we are not at the provisional measures stage. As to the judgment on preliminary objections in these same cases, it is hard to tell how Russia can believe they are in the least bit relevant. The court only ruled that Serbia and Montenegro had no standing to appear before the court at the time of the filing of its application, without saying anything whatever about Article 9. Here yet again, this has nothing whatever to do with the instant case. For the sake of exhaustiveness, I will add that Russia has yet again relied in vain on Article 147 of the judgment on the merits of the Bosnian genocide, as it did last Monday. In that paragraph, the court stated that under Article 9 of the Convention, it could not rule on claims of breaches of international conventions and of customary international law if they were unrelated to the Genocide Convention. In so ruling, the court was responding to the many submissions made by the applicant, which relied on another basis for competition than Article 9 of the Convention. In its judgment, the court dismissed this other basis for jurisdiction and established it could therefore only rule pursuant to Article 9. It concluded that it could not exercise its jurisdiction, established only on the basis of Article 9 of the Convention, regarding the applicant's submissions, which exclusively covered breaches of the Geneva Conventions, of human rights treaties, of the United Nations Charter, and customary international law. The contrast with the present case is thus absolutely striking, since Ukraine has only invoked Article 9 as a basis for jurisdiction and is only asking the court to find that the Convention has been breached. Madam President, I may stop for a moment here, if you wish, if you believe this is the right time, for a break.
I thank Professor Tuvenen. I see that the next section of your speech is rather short, so perhaps you could just complete that section, and after that we'll take a break. Thank you.
Parfait, Madame la Présidente. Je vous remercie.
Very well, Madam President. Thank you very much. Madam President, I need to briefly address one of Russia's other fixations, the relationship between the Convention and the use of force, which my colleagues have already discussed, but which I would like to come back to just very briefly. On this point, the opposite side, on the other side of the aisle, attempted to prove I had contradicted myself by putting side by side two sentences I uttered last week. They recalled I had both said that Article 1 of the Convention does not confer a right to use of force, and that the Convention does not prohibit all use of force. One of Russia's counsels thought he had detected, and I quote, some clear hesitance. Did I say that the Convention conferred a right to use force unilaterally? His colleague then implied, in his own way, that the subtlety of my point had entirely escaped him. Yet it was perfectly elementary. The court on 2 occasions ruled that the measures that a state must and may take to prevent a genocide and prosecute its perpetrators must remain within the limits allowed by international legality. It follows that a state has the right to prevent and punish genocide pursuant to the Convention by undertaking various actions, including by using force, if it remains within the limits allowed by international legality. For example, if the UN Security Council considers that a genocidal situation in a given country constitutes a threat to international peace and security, the Council may decide to authorize the use of force to put an end to this genocide. You will all remember that in the case of Rwanda, the Security Council was not exactly efficient, but it did adopt Resolution 929, brackets 1994, permitting the use of force in Rwanda to prevent mass killings, which, as we know, were qualified as genocide. And the state parties to the Convention on Genocide were clearly permitted to act to put an end to the genocide in Rwanda, including, if need be, by using force within the limits set by the Security Council. Certain states did so more or less successfully, it must be said. Similarly, the use of force with the stated claim to prevent and punish a genocide can remain within the limits of international legality if the said use of military force is a self-defense measure. That is assuming, of course, that the conditions for the right to self-defense are duly satisfied and that the measures taken are indeed lawful acts of self-defense. As to Russia's claim that Russia acted according to its right to self-defense when it launched actions to prevent a purported genocide in Ukraine, the court will hear what Russia has to say about this, but only at the merits stage. At that point, Russia will be free to explain, if it so wishes, that its actions to prevent and punish the purported genocide are also measures of self-defense, and that accordingly it has performed its obligation to apply and fulfill the Convention in good faith by using all reasonable means at its disposal, and by respecting the limits permitted by international legality. The court will judge. In short, the Genocide Convention does not prohibit all use of force for its fulfillment. That is what I stated last week. It is nevertheless true that the Convention, as such, does not grant a right to the use of force. It obliges states to act to put an end to genocide and allows them a margin of discretion as to the choice of means they enlist to this end. But it does not, of itself, grant the right to use force. I shall later address the issue of discretionary power and abuse of right, other elementary notions which our friends opposite have some difficulty comprehending. But that, if you wish, will be after the break, Madam President.
Thank you, Professor Tuvenan. Indeed, this is an appropriate time for the court to adjourn for a coffee break of 10 minutes. The sitting is adjourned. Please be seated. The sitting is resumed, so I now invite Professor Tuvenen to complete his presentation. You have the floor, Professor.
Merci, Madame la Présidente.
Thank you, Madam President. Madam President, distinguished members of the Court, our opponent's third obsession, that was already addressed last week, is an obsession that I still need to come back to it. It is the fact that, in fact, Ukraine would like to include an indefinite number of obligations in the Convention coming from different sources of international law and that are not in the Convention, and that unduly extend the scope of Article 9 and the Court's jurisdiction res judicata materia. Russia fears that Article 9 will become a black hole that will suck in all sorts of disputes that have nothing to do with the interpretation, application, or fulfillment of the Convention. It fears, in short, that Article 9 will morph into a universal compromissory clause. But contrary to what our opponents have hammered home, there is nothing in Ukraine's submissions or even, in fact, in their oral presentations that resembles such a claim. Even the intervening states, in fact, did not detect any such indication in Ukraine's pleadings, and nothing justifies Russia's fears. The fact remains that the actions that the states parties to the Convention may take to perform their obligation to prevent genocide and to punish its perpetrators under the Convention must remain, as your court held, and I quote, within the limits permitted by international law, end of quote. In saying so, the court has merely interpreted Articles 1 and 4 of the Convention by determining the extent of the obligations and powers they contain. I already addressed this point last week, so I will not come back to it, except perhaps to recall that in interpreting these provisions, the Court did not in any way include rules of international law in the Convention that do not exist in the Convention, nor did this Court proceed with a prohibited incorporation when it ruled that having jurisdiction under Article 9 alone does not prevent it from considering in its reasoning whether a violation of international humanitarian law or international humanitarian rights law has occurred to the extent that this is relevant for the Court's determination of whether or not there has been a breach of an obligation under the Genocide Convention. And there was nothing either that resembled an unbridled incorporation of external rules into the treaty when, pursuant to Article 31, paragraph 3c of the Vienna Convention on the Law of Treaties, the Court interpreted this treaty in the light of, and I quote, any relevant rules of international law applicable in the relations between the parties. End of quote. Madam President, now that the points that Russia has fixated on are behind us, let me turn to the role of interpretation, application and fulfillment of the Convention in good faith. Here again, Mr. Crossato was forced to distort Ukraine's arguments so as to refute them, while acknowledging that, and I quote,
So, expressly.
Ukraine does not say so expressly. According to him, Ukraine's ulterior motive is to demonstrate that if a state does not perform the Convention in good faith, the Court's jurisdiction under this Convention may extend to allegations of violations of rules external to the treaty, which could have some connection with the improper performance of the treaty. And my opponent replied to this ulterior motive that the good faith principle is not an autonomous source of obligations and therefore cannot create obligations for the parties to the Convention if these obligations are not already included in the Convention. This is not what Ukraine argues. Ukraine contends that the court has jurisdiction by virtue of Article 9 to settle a dispute on the interpretation, application, or fulfillment of the Convention, which allegedly is not done in good faith, that is, which is allegedly contrary to its object and purpose, or, and if these two aspects are combined, it is even more blatant, or which is purportedly radically contrary to the purposes for which the Convention was adopted. Such conduct would manifestly be a breach of the Convention, and needless to say, in order to determine whether Russia has breached its obligation to interpret, apply, and fulfill the treaty in good faith, in its reasoning, the court, if it deems necessary, can refer to other violations without transforming its role, which is limited by Article 9. Madam President, distinguished members of the Court, Ukraine is perfectly aware that the Court has already ruled that the good faith principle in itself is not a source of obligation when none would otherwise exist. But when a treaty is binding on parties, it is the Court's dictum in Gapshikovo-Nagimarosh that sheds light on the role of good faith in treaty relations, and I quote, "Every treaty in force is binding upon the parties to it and must be performed by them in good faith." This latter element, in the Court's view, implies that in this case it is the purpose of the treaty and the intentions of the parties in concluding it which should prevail over its literal application. The principle of good faith obliges the parties to apply it in a reasonable way and in such a manner that its purpose can be realized. End of quote. The purpose of the Genocide Convention is to rid humanity of the scourge of genocide. It is with this aim that states parties undertook to prevent and punish genocide. It is this purpose in compliance with the state party's intention which governs and which should govern the interpretation, application and fulfillment of Articles 1 and 4 of the Convention. Ukraine argues that there can be no conduct more contrary to these requirements than the one adopted by Russia and denounced by Ukraine in the present case. Ukraine also contends at this stage of the proceedings that the Court clearly has jurisdiction, ratione materii, to adjudge this case on the merits. Distinguished members of the Court, let's move to the abuse of rights. It is clear that our opponent's key argument in seeking to exclude this claim from your jurisdiction, ratione materii, consists in saying that Russia has acted and continues to act in and against Ukraine to prevent and punish an imaginary genocide without the Convention giving it the right to do so, even if it has relied on it to justify its actions. Russia, therefore, could not have abused a right not conferred on it by the Convention, it says. However, it is obvious that Russia has a rather restricted understanding of abuse of rights. Firstly, it is permitted to address the notion of abuse of rights as a sort of lesion on the principle of good faith, that is to say, a violation of this principle. As Karl Stupp pointed out in his special lecture given at the Hague Academy of International Law, or, and that amounts to the same thing, that it is a corollary of the principle of good faith, as the dictionary of the late Jean Salmon states. And from this viewpoint, the invocation of abuse of rights is another way of addressing the obligation to interpret, apply, or fulfill the Convention in good faith that I have just mentioned. But abuse of rights can also be addressed independently by considering that it is characterized, and here I quote Jean-Paul Jacquet's lecture, when a state uses some of its powers for a purpose other than that provided for by international law. And in the same vein, George Abisab, during his general course at the Academy, stated, with respect to countermeasures that, and I quote, the misuse of the institution or its use as a pretext for unavowed purposes falls under the prohibition of abuse of rights. End of quote. In the present case, Russia's conduct, as denounced by Ukraine, is the most perfect example of abuse of rights to prevent and punish genocide. Russia is using some of the powers provided for by the Convention for purposes that are totally unrelated to it, or that are in fact radically contrary to the purposes provided for by the Convention. Russia has subverted the Convention by using it for not just unavowed purposes, but also for purposes that are terribly damaging, not only for Ukraine, but also for the international community, which is clearly an abuse of rights. In addition, even if we were to follow my opponent's restricted logic, the fact remains that the Convention expressly confers the right to take certain actions should genocide occur. Article 8 enshrines the right to seize the competent organs of the United Nations Organization. It is clearly stated in Article 8 that any contracting party may call upon the competent organs. It is not a duty, it is a right. It is a permission, as I said last week. It is a right whose scope is not specified either in Article 1 or in Article 4, but specifically in Article 8. Similarly, Article 9 confers a right on any state, whether directly injured or not, to take action to put an end to genocide by engaging the responsibility of a state and, if need be, which is something different, by seizing the court if there is a dispute in this regard. The Convention, and particularly Articles 1 and 4, also allow states, that is to say, recognize their rights, to take other actions that it does not explicitly define, recognizing that they have discretionary but not unlimited power to decide. Russia states that it does not believe that parties have discretionary power under the Convention to decide in what manner they should fulfill their obligations. However, the Court considered that while it is clear that, and I quote, Article 1 does not specify the kinds of measures that a contracting party may take to fulfill this obligation. However, the contracting parties must implement this obligation in good faith, taking into account other parts of the Convention, in particular Articles 8 and 9, as well as its preamble. And the same articulation, which in fact is quite an obvious one, can be found in Djibouti versus France, in which the Court held that if the terms of Article 2 of the Convention relevant to this case, and I quote, provide a state to which a request for assistance has been made with a very considerable discretion, this exercise of discretion is still subject to the obligation of good faith codified in Article 26 of the 1969 Vienna Convention on the Law of Treaties. In other words, no discretionary power is unlimited. No discretionary power recognized by a convention is unlimited. As to the Genocide Convention, the Court has determined the lower limit, that is to say, a floor, by ruling that all states must use all means reasonably available to them. The Court has also established the upper limit, or a ceiling, by interpreting the Convention as requiring any action to prevent and punish genocide within the limits permitted by international law. Within those limits set by the Convention itself, if correctly executed, the Convention provides discretionary powers to states and therefore confers the states parties with rights to determine and take the actions required to prevent and punish. This amounts to saying, as the court held, that, and I quote, a contracting party may resort to other means of fulfilling its obligation to prevent and punish genocide that it believes to have been committed by another contracting party, such as bilateral engagement or exchanges within a regional organization. However, the court emphasizes that in discharging its duty to prevent genocide, every state may only act within the limits permitted by international law. End of quote. It is on this basis that Ukraine argues that Russia's conduct, which is at question in this case, is not only a breach of Articles 1 and 4 of the Convention, as interpreted by the court, but also a manifest abuse of these articles in that Russia has claimed to fulfill its obligations under the Convention by taking action that is the very opposite of what the Convention permits within the limits of international law, and which is the exact opposite of the purposes for which this Convention was designed. There can be no more serious an abuse than this. At this stage, Ukraine is not asking the court to rule on any abuse. It simply contends that its allegation in this regard, like the others, falls within the court's jurisdiction ratione materiae. This concludes my presentation today. Madam President, distinguished members of the court, I am aware that I always give the interpreters a very hard time, and I would like to commend them for their consistently talented performance. I thank you for your kind attention and request you to give the floor to Mr. Zions. Thank you.
Tuvin, and I now invite Mr. David Zions to address the court. You have the floor, sir.
Madam President, members of the court, I am honored to appear before you again on behalf of Ukraine. My task is to address Russia's admissibility objections, which remain entirely without basis. I turn first to Russia's third preliminary objection regarding supposedly new claims. On Monday, Russia's counsel spoke at length about the Nauru case, yet he ignored the decisive question in Nauru: whether the subject of the dispute originally submitted to the court would be transformed if the court entertained the claim. Russia even faulted Ukraine for crystallizing the overall subject matter of the dispute, rather than parsing it into various specific issues. One wonders how Russia expects the court to decide if the subject of the dispute has been transformed without identifying the dispute's fundamental subject matter. To this overarching legal point, I add 4 brief factual ones. First, Russia believes the application does not refer to the subject matter of the dispute, as Ukraine has summarized it during this hearing. On your screen is Ukraine's concise crystallization of the dispute that Russia's counsel does not like. And next to it, the first substantive paragraph of Ukraine's application. The court can decide whether there has been some radical transformation. Second, I refer the court to paragraph 27 of Ukraine's application, which identifies a duty located in Article 1 of the Genocide Convention and describes Russia's conduct as something a state may not do, consistent with that duty. This, together with the parts of the application I highlighted last week, confirms that Ukraine has always claimed that Russia violated the convention. Third, Russia considers Ukraine's reliance on Article 4 inadmissible because the application purportedly did not concern anything, quote, related to criminal punishment, end quote. Yet the application addressed prevention and punishment of genocide and highlighted President Putin's speech of 24 February. That speech declared that the purpose of the so-called special military operation was to stop the alleged genocide and to bring to trial those who perpetrated it. Fourth, with respect to Ukraine's non-violation claim, i.e. requesting a declaration that it has not violated the Genocide Convention, Russia believes that Ukraine has, quote, dropped its initial claim that there are no genocidal acts in Donetsk and Luhansk, end quote, and now asserts only that, quote, Ukraine as a sovereign state is not responsible for them, end quote. This is not a remotely fair reading of the application or the memorial. Russia omits that in the application, Ukraine requested a declaration that no acts of genocide had been committed, contrary to what the Russian Federation claims. There is no mystery as to who the Russian Federation claims was responsible for committing genocide: Ukraine. Madam President, members of the Court, I will briefly return now to Russia's fourth objection, alleging that any possible judgment would be devoid of purpose. To maintain this objection, Russia continues to ignore several of Ukraine's submissions. It focuses on one request for the termination of Russia's use of force, noting that this submission does not itself use the words genocide or genocide convention. But Ukraine claims that Russia's use of force violates the Genocide Convention. Ukraine's termination request simply seeks cessation of the act that violates the convention. As Ukraine has already explained, Russia's reference to self-defense establishes nothing about the inherent ineffectiveness of Ukraine's requested order. At most, it raises questions about the merits or perhaps the scope of relief. In any event, Ukraine also requests other relief. Take Ukraine's request for a declaration that there is no credible evidence it is responsible for committing genocide. Since 2014, Russia has alleged that Ukraine was committing genocide. Just last week, the Russian agent disturbingly accused Ukraine of planning a final solution for Donbass. And when Russia launched its full-scale invasion of Ukraine, the stated purpose and goal of Russia's use of force was to stop this genocide. In this context, the declaratory judgment Ukraine requests would have practical effect. In the words of Chorzo Factory, the legal position thus established could not again be called in question. Would Russia truly persist in alleging that Ukraine violated the convention? Would Russia truly continue acting for the purpose and goal of stopping a genocide committed by Ukraine in the face of a judgment by this court declaring there is no credible evidence that this alleged genocide is occurring? The court cannot assume so as a basis for declining to exercise its jurisdiction. Consider also Ukraine's request for declarations that Russia's use of force and its recognitions of the so-called DPR and LPR violate Articles 1 and 4 of the Genocide Convention. The fact that Russia violated the convention through a use of force does not make a potential judgment devoid of purpose. This court had no such concern in oil platforms, where, as my colleagues already noted, the applicant requested a declaration that a particular use of force violated not the UN Charter, but a treaty under which the court had jurisdiction. Madam President, members of the court, I turn now to the admissibility of Ukraine's claim requesting a declaration that it has not violated the Genocide Convention. It is worth noting the limits of Russia's objection to this claim. Russia does not object to the court's jurisdiction ratione materiae to assess Russia's allegations that Ukraine is responsible for committing genocide. Russia makes the more limited argument that the court should treat Ukraine's request for a declaration on this question as inadmissible, that is, to decline to exercise jurisdiction the court admittedly possesses. To be clear, Ukraine's case is about more than Russia's allegations of genocide in isolation. The subject matter of the dispute is Russia's reliance on allegations of genocide to harm Ukraine. Ukraine's requested non-violation declaration is legally intertwined with this subject matter. Ukraine alleges that Russia relied on false allegations of genocide to act against Ukraine, without even having credible evidence that those allegations are true. Ukraine also seeks important additional relief, some of which I've just recounted. But questions about whether the court should order all, some, or none of the relief that Ukraine requests, or should fashion some other remedies that the court deems appropriate, is a classic question for the merits, after the court has weighed the facts and fully interpreted the treaty. At present, the notable point is that Russia has no meaningful argument against the jurisdiction of this court. The parties unquestionably disagree over Ukraine's alleged responsibility for genocide, and the court has jurisdiction to resolve that disagreement. Full stop. With this in mind, I turn to the question of the admissibility of that claim. The court can begin and end its analysis with Article 9's text. Under its ordinary meaning, if there is a dispute over responsibility for genocide, any of the parties to that dispute may bring it to the court. On Monday, Russia reiterated its view that only a state that accuses another state of genocide may seize the court. Russia's counsel even invented a rule out of nothing. Quote, "The claim shall be filed by a state that invokes the responsibility of the other state," end quote. In other words, according to Russia, in a dispute between two states over responsibility for genocide, only one of the parties to that dispute may submit it to the court. The disconnect between the treaty's text and Russia's argument can end the discussion. But if that were not enough, Russia makes 4 additional errors. First, Russia relies on the travaux préparatoires to argue that the phrase "any of the parties" was, quote, "merely editorial in nature," end quote, and so can be disregarded. In light of the clarity of the text, resort to the negotiating history is unnecessary. But in any event, Russia's selective presentation of that history is misleading. In an early draft, the compromissory clause would have provided in simple terms that disputes shall be submitted to the court, without any reference to who may submit the dispute. A series of amendments followed. The United Kingdom proposed that disputes would be referred to this court at the request of any party to the dispute. This amendment was then consolidated with a Belgian proposal, yielding a joint amendment under which disputes would be submitted to the court at the request of any of the high contracting parties. The Indian delegate felt that that change of wording did not improve the text and proposed a formulation closer to the original UK proposal at the request of any of the parties to the dispute. It was this reversion from any of the high contracting parties back to any of the parties to the dispute that the French delegate said could be accepted as, quote, "merely a drafting matter," end quote. In other words, the drafting matter was a choice between 2 any's. Under either version, any party could turn to the court. From this history, there is no basis for inferring that the word "any" was editorial or otherwise unimportant. Second, Russia cannot ground its admissibility objection in the court's jurisprudence. Certainly, there is no decision of the court that rejects the admissibility of a non-violation declaration. Even if there were no direct precedent, the alleged novelty of a particular type of claim is not a legal reason for the court to decline jurisdiction that has been duly conferred on it. In any event, non-violation claims are not unprecedented. In the Rights of Nationals and Lockerbie cases, the court entertained such claims. Russia accepted this point in the first round, saying merely that the court, quote, did not rule on the disputed legal point, end quote. In the second round, Russia backtracked, suggesting that in Lockerbie, the court might have implicitly rejected Libya's non-violation claim. Merely glancing at the dispositive paragraphs of the court's judgment confirms that the court dismissed all of the United Kingdom's objections and allowed all of Libya's claims to proceed to the merits. That includes its non-violation claim. Recall what Russia is saying, that a non-violation claim, quote, is incompatible with the judicial function of the court, end quote. If that were so, surely the court would have said something in Lockerbie and Rights of Nationals, even on its own initiative, upon being asked to act beyond its judicial function. Indeed, in northern Cameroons, the court raised, proprio motu, its concern that adjudication, quote, would be inconsistent with its judicial function, end quote. The court's silence in Rights of Nationals and Lockerbie confirms that there is nothing judicially improper about the court declaring a state to be in compliance with its obligation when that is in dispute. Little needs to be said of the irrelevant differences Russia has seized on to distinguish these cases. I will just note the oddity of Russia's point that in Rights of Nationals, the issue did not have the same, quote, magnitude as genocide, end quote, or involve obligations erga omnes. The magnitude of the issue of genocide and the erga omnes character of the obligations at issue is a point in favor of broad access to judicial resolution. This case illustrates why. A false allegation of genocide can form an unjust basis for taking action against that state. By declaring that there is no credible evidence that an alleged genocide is in fact occurring, the court can resolve the factual issue at the heart of this dispute that forms the predicate for Russia's ongoing actions. As the court noted in its provisional measures order in this case, it is mindful of its own responsibilities in the maintenance of international peace and security, as well as in the peaceful settlement of disputes under the Charter and the statute of the court. Far from Ukraine's request being incompatible with the court's judicial role, the court is asked to discharge its most vital judicial responsibility. Third, Russia objects that Ukraine's claims may entail fact-finding, while conditions in Donbass, quote, make any fact-finding work on site very difficult, if not impossible, end quote. The notion that fact-finding in Donbass is impossible would come as a surprise to the UN Human Rights Monitoring Mission in Ukraine and the OSCE and the Office of the Prosecutor of the ICC. In any case, a respondent's assertion that fact-finding might prove difficult is not a ground for finding a claim inadmissible before the facts are even at issue. Fourth and finally, there is no reason to credit Russia's concerns over the res judicata effect of a judgment on a, quote, patently incomplete set of evidence, end quote. This is just Russia's speculation about a future evidentiary record. Ukraine submits that the record, including many reports from the bodies I just mentioned, will support a conclusion that there is no credible evidence of Ukraine's responsibility for genocide. But the court will assess that for itself at the merits stage. When the court issues whatever judgment it finds supported and appropriate, there is nothing problematic about that judgment being res judicata between Russia and Ukraine. A binding judgment based on the best available factual record and a full airing of the legal issues is precisely the point of referring disputes to the court for a final resolution. An even more basic point, however, is that a claim cannot be dismissed as inadmissible based on hypotheticals. The court has ample tools to address Russia's professed concerns when, or if, they ever actually arise. Finally, Madam President, members of the court, regarding Russia's sixth objection, Russia has not identified anything close to the extraordinary circumstances that could constitute an abuse of process by Ukraine. Russia relies on a willful misreading of Ukraine's case in order to sow confusion. After pointing to different statements made in different contexts, Russia's counsel sarcastically asks, so, is it Russia's or is it Ukraine's liability we are looking into? The answer is not difficult. Both. The dispute relates to Ukraine's liability because the parties disagree over whether Ukraine is responsible for genocide. And the dispute relates to Russia's liability because the parties disagree over whether Russia has misinterpreted, misapplied, misfulfilled, and violated the Genocide Convention. Russia cannot claim abuse of process by feigning confusion over Ukraine's straightforward and consistent case. Russia also cannot claim abuse of process just because it feels victimized by the legal interpretations of 32 intervening states. At times, Russia complains that the interveners' interpretations are too similar to Ukraine's. Other times, Russia complains that the interveners' positions are too different from Ukraine's. The inconsistency of Russia's position aside, neither situation is an abuse. In the whaling in the Antarctic case, New Zealand, as the intervener, explained, quote, "We acknowledge that the points we make may differ in substance or in emphasis from those of the parties. That is entirely to be expected," end quote. The interventions this court heard last week likewise proceeded as Article 63 of the statute envisions. Indeed, the interveners' oral pleadings were studiously focused on the questions of interpretation before the court, in stark contrast to Russia's extraneous presentations about all manner of irrelevant topics. And if the court finds that any of the interveners' submissions strayed beyond their authorized scope, it already said in its order that it would simply disregard such remarks. Dismissing Ukraine's case as an abuse of process plainly would not follow. Russia's charges of hypocrisy against the interveners also fall flat. As Professor Coe explained, the interpretive issues in this case are quite different from those in the legality of the use of force cases. For that reason, and for all of its rhetoric, Russia could not identify a single statement from those cases in which the interveners interpreted Articles 1, 4, or 9 of the Convention differently than they do now. Russia may speculate that, quote, "the intervener's intent is purely instrumental," end quote, but a complete answer to that charge is Article 63 itself. As the statute requires, each of the interveners agreed to be bound by the court's interpretation. The interveners are not engaged in cheap talk. They have something important to say about important questions of law, and they have willingly accepted the stakes of saying it here. Ultimately, the historic interventions in this case are not an abuse, but a reflection of the importance of the interpretive issues in this case. The Genocide Convention is a special treaty. It establishes obligations erga omnes. And this case raises interpretive issues that are unique and profound. Whether the most noble human rights instrument may be repurposed for the most ignoble ends. Madam President, members of the Court, this concludes my remarks confirming the admissibility of Ukraine's claims. I thank the Court for its attention, and I now ask that you give the floor to Mr. Jonathan Gimblett.
I thank Mr. Zients, and I now give the floor to Mr. Jonathan Gimblett. You have the floor, sir.
Madam President, members of the Court, it is an honour to appear before you again on behalf of Ukraine. I will respond to Russia's limited remarks concerning Ukraine's claim that you have jurisdiction over Russia's violation of the Court's order on provisional measures. Russia's brevity on this issue on Monday was really an excuse to duck some critical issues. First and foremost, does Russia accept that it has a binding legal obligation to comply with the Court's order? According to the statement by Dmitry Peskov, the spokesman of the Russian president the day after the order issued, Russia does not. In his words, Russia could not take account of the order because it had not consented to do so. Whatever Russia's lawyers may say here in The Hague, we know that Mr. Peskov's words are a truer reflection of Russian government policy, because Russia has continued its full-scale military invasion of Ukraine since the 16th of March 2022, in defiance of this Court's order to immediately suspend all military operations on the territory of Ukraine. Indeed, as Ukraine's co-agent will describe, Russia's brazen non-compliance with that order has continued to result in civilian deaths and damage to critical infrastructure over the last 10 days of these hearings. On Monday, Russia sought to deflect attention away from this core issue by misstating Ukraine's position and misapplying the Court's jurisprudence. As to Ukraine's position, contrary to the impression given by Russia, Ukraine is not asking you to rule on Russia's non-compliance with the Provisional Measures Order as part of this preliminary objections phase of the case. This is clear from the submissions included in Ukraine's written statement on Russia's preliminary objections, which asked you to, and I quote, adjudge and declare that the Court has jurisdiction to hear the claims presented by Ukraine as set forth in its application and memorial, and that those claims are admissible, and to proceed to hear those claims on the merits. Ukraine's claim that Russia is violating the procedural measures, the Provisional Measures Order, and its request for reparations was set forth in Ukraine's memorial. As I explained last week, Ukraine has demonstrated that the tribunal has jurisdiction to hear Ukraine's substantive claims on the merits, and that those claims are admissible. As a matter of procedural efficiency, Ukraine's expectation is that the Court will address Russia's non-compliance with provisional measures alongside the merits of Ukraine's substantive claims. But also implicit in the submissions I just read to you is the notion that even if you were to uphold Russia's preliminary objections as to Ukraine's underlying substantive claims, you can and you should exercise jurisdiction and proceed to the merits on Ukraine's claim concerning provisional measures. Russia voiced no objection on Monday, or in its written pleadings on preliminary objections, to the court exercising jurisdiction over Ukraine's provisional measures claim if the court finds it has jurisdiction over the substantive claims. Most of the cases that it cited with approval were ones in which the court had found it had jurisdiction over the merits of an applicant's substantive claims and decided to address alleged violations of provisional measures at the same time. Such was the case in Qatar versus United Arab Emirates, the 2019 judgment of the court in the ICSFT and CERD case, in the Treaty of Amity case, and in the Gambia versus Myanmar. The court may therefore take it as a point of agreement between the parties that it has jurisdiction to address Ukraine's non-compliance claim on the merits if it finds jurisdiction over one or more of Ukraine's substantive claims. Russia appears, however, to take the position that the court will lack the power to address its non-compliance with provisional measures if the court finds that it has no jurisdiction over Ukraine's substantive claims. This is presumably the twisted way in which Russia hopes to reconcile its refusal to heed the court's order with its declared respect for the court as an institution. In Russia's view, if the court ultimately lacks the power to address Russia's brazen non-compliance with provisional measures, those measures will effectively become retroactively non-binding. But of course, that is incorrect. The court's authority is not so transitory in nature. The only support that Russia advanced on Monday in support of this position was its own flawed interpretation of the court's rulings in request for interpretation of the Avena judgment, a case to which I referred in my remarks last week. The point I was making then was that the court had found itself competent to address the United States' violation of a provisional measures order in that case, even though it ruled that Mexico's substantive claim was, quote, outside the jurisdiction specifically conferred on the court by Article 60 of the court statute. That finding on jurisdiction is reflected in paragraph 45 of the court's 19th of January 2009 judgment in the case shown on the present slide. Paragraph 51 of the same judgment makes clear that notwithstanding the court's decision not to exercise jurisdiction under Article 60, it was still able to address the United States non-compliance by virtue of its, quote, incidental jurisdiction to make findings about alleged breaches of the order indicating provisional measures, end quote. In my remarks last week, I explained that this incidental jurisdiction is inherent in the power to indicate provisional measures conferred on the court by Article 41 of the statute, and that Article 41 would be deprived of its effectiveness if the court lacked the power to address violations of the provisional measures so indicated. The absence of a specific reference in Article 41 to the court's power to assess violations of provisional measures is neither surprising and nor is it an obstacle to inferring the existence of such a power. It's not surprising because it is in the nature of foundational documents like the statute of the ICJ that they typically do not contain an exhaustive list of all the functions and powers of the institutions to which they relate. It is not an obstacle because this court has found on many occasions that powers not expressly mentioned in an organisation's constituent instruments can nonetheless be implied based on the functions accorded to the organisation in question. For example, in its 1949 advisory opinion in reparation for injuries suffered in the service of the United Nations, the court held that, quote, under international law, the organisation, that is the United Nations organisation, must be deemed to have those powers which, though not expressly provided in the Charter, are conferred upon it by necessary implication as being essential to the performance of its duties. The language that I cited last week from Request for Interpretation of the Avena judgment is consistent with this understanding. In its attempt to distinguish the case, Russia completely misses the point. Instead of focusing on the court's January 2009 judgment explaining the basis on which it could exercise jurisdiction over non-compliance with the Provisional Measures Order, Russia pointed you to language in paragraph 44 of the July 2008 Provisional Measures Order in that case, which has nothing to do with the issue at hand. Specifically, Russia showed you the language now on the screen, which reads, whereas the court's jurisdiction on the basis of Article 60 of the statute is not preconditioned by the existence of any other basis of jurisdiction as between the parties to the original case, and whereas it follows that even if the basis of jurisdiction in the original case lapses, the court nevertheless, by virtue of Article 60 of the statute, may entertain a request for interpretation. This passage merely explains how it is that the court could exercise Article 60 jurisdiction over the substantive claim advanced by Mexico, a request for interpretation, even though the basis for jurisdiction in the original Avena case, a claim arising under the Vienna Convention on Consular Relations, had lapsed. It has nothing to do with the court's jurisdiction to address a subsequent alleged violation of provisional measures in the interpretation proceedings. The conclusion that Russia's counsel drew from this irrelevant passage, the use of the word lapsed, indicates that, quote, jurisdiction in the original case is still a must, end quote, is equally besides the point. In short, the present case involves no request for interpretation, Article 60 is not in play, and nor is its relationship to an original basis for jurisdiction. Evidently, then, Russia has failed to engage with Ukraine's position that the court has jurisdiction to address Russia's non-compliance with the court's Provisional Measures Order, even if it lacks jurisdiction over Ukraine's substantive claims. Russia similarly failed on Monday to address a separate basis for the court's jurisdiction, outlined in my remarks last week and expanded upon by Mr. Williams, the representative of New Zealand, last Wednesday. That is, that Ukraine's claim that Russia has not complied with the court's binding Provisional Measures Order and owes reparations as a result is a distinct claim arising directly under Article 9 of the Genocide Convention. By acceding to the Genocide Convention, Russia assumed an obligation to comply with its mandatory dispute resolution procedures and to do so reasonably and in good faith. Ukraine's claim that Russia has violated that obligation by failing to comply with provisional measures ordered by the court, which Russia contests, is therefore a dispute relating to the interpretation application, or fulfillment of the Genocide Convention, falling directly within the Court's jurisdiction under Article 36(1) of the statute. To sum up, at this stage of the proceedings, Ukraine is asking you to find that you can exercise jurisdiction over Russia's non-compliance with provisional measures. The parties appear to agree that you can do so if you find jurisdiction over any of Ukraine's substantive claims. For the reasons I've outlined, Ukraine submits that you also may exercise jurisdiction under Articles 36 or 41 of the statute, even if jurisdiction over the substantive claims is lacking. Madam President, that concludes my remarks. I respectfully request that you call next Ms. Oksana Zolotarova, the co-agent of Ukraine, who will deliver some closing remarks and read the submissions of Ukraine.
I thank Mr. Gimlet, and I now invite the co-agent of Ukraine, Ms. Oksana Zolotarova, to address the Court. You have the floor, Madam.
Madam President, distinguished members of the Court, I am honored to stand before you to make concluding remarks and present final submissions of Ukraine. Last week, the agent of Ukraine recalled that, and here I quote, 573 days ago, Russia launched a brutal, full-scale military assault on Ukraine, end of quote. He explained that Russia has inflicted this devastation on Ukraine for an express, clearly stated purpose, preventing genocide and punishing the perpetrators of genocide. As Ukraine has explained, when Russia acted for this specific purpose, it placed its own acts within the framework of the Genocide Convention. This court plays a vital role in safeguarding the Genocide Convention, guaranteeing its compliance and protecting it from abuse. That's why Ukraine is here. Today, as this hearing comes to a close, it has been 581 days since Russia unleashed these horrors. Here in The Hague, Russia paints itself as a victim. In Ukraine, Russia has continued to show its true colors. Last Tuesday, in The Hague, we stood before you and pled our case. Last Tuesday, in Ukraine, Russia unleashed a drone attack on the city of Lviv in western Ukraine. The attack killed civilians and burned down the warehouse of a Roman Catholic charity. The UN humanitarian coordinator for Ukraine, and here I quote, condemned in the strongest terms the Russian airstrike. She said that, I quote again, vital humanitarian facility, which contained approximately 300 tons of relief supplies, was burned to the ground. End of quote. Last Wednesday, in The Hague, the court heard historic legal arguments from 32 intervening states. The very next morning in Ukraine, people across my country woke up to cruise missiles. Russia targeted civilian infrastructure across the country, causing blackouts in Rivne, Zhytomyr, Kyiv, Dnipro, and Kharkiv. In Kyiv, the Russian missile attack injured a 9-year-old girl. Russia is reminding us that this winter it will try again to terrorize our people and freeze us into submission. This past weekend in The Hague, Russia prepared what I can only call a propaganda show. Over this weekend in Ukraine, Russia launched airstrikes in the Kherson region, killing at least 2 civilians and injuring many more. This Monday in The Hague, Russia made its final plea to escape your jurisdiction. Monday morning in Ukraine, we surveyed the damage from an overnight attack on the port of Odessa, a blatant attack on Ukraine's economy and its ability to feed the world with its grain. Russia launched this attack on the evening of the Yom Kippur, a Jewish holiday, in an important city for Ukraine's Jewish community. On the same day, Russia stood in this court and repeated its slander that Ukrainians are neo-Nazis. Madam President, members of the court, we turned to you a year and a half ago because we were in dire need of protection. We still need your protection today. Russia's lawyers have lectured us, saying that state must wait years before the court can decide a case about whether the genocide is taking place. Ukraine does not have that luxury of time. When Russia used its false allegations of genocide as a pretext to attack us, we had no choice but to come to this court immediately. We have been brutally attacked based on the false allegations of genocide. Russia has repeatedly claimed that Ukraine violates the Genocide Convention. Russia's president said it clearly, repeated by official after official. It is attacking to prevent and punish genocide. Preventing and punishing genocide is the subject of the Genocide Convention. Russia is a party to the Genocide Convention. It agreed to your jurisdiction over disputes relating to the interpretation, application, or fulfillment of the Genocide Convention. It was completely logical for Ukraine to invoke that jurisdiction and bring its dispute under the Genocide Convention to this court. Russia tries to cloud the issues, distorts Ukraine's claims, and ignore objective reality. Russia professes not to understand Ukraine's case, but Ukraine's case is straightforward. Russia has made false allegations of genocide under the Genocide Convention. It used those allegations as a pretext to recognize the so-called DPR and LPR and to use force in and against Ukraine. Russia is abusing its right under the Convention and abusing the Convention as a whole. Russia is not performing its obligation to prevent and punish genocide in good faith. Russia is failing to act within the limits of international law when it acts to prevent and punish genocide. It is obvious why Russia tries to make the case seem more complicated than it is, but when the court looks at the actual disputes and Ukraine's actual claims, the jurisdiction of the court is clear. Russia also worked hard to ignore its own state purpose for the full-scale invasion. Last week, the agent of the Russian Federation, the agent of Ukraine, highlighted the specific words of the Russian president, which Russia's agent and counsel had ignored. This Monday, the court gave Russia 6 hours. Russia used this for propaganda and irrelevant arguments. Not once did you hear Russia's acknowledged President Putin's statement of purpose for his full-scale invasion of Ukraine. So I have no choice but to recall the actual stated purpose of Russia's actions. I quote, "The purpose of this operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kiev regime." I quote again, "We had to stop that atrocity, the genocide of the millions of people who live and who pinned their hopes on Russia, on all of us." End of quote. Russia quickly dismissed this as providing, and I quote, "a wider context of the situation where genocide was mentioned among other factors." We should not, Russia, be evasive. This was not a mention. It was not wider context. It was not a rhetorical statement. It was the only stated purpose of the Russian full-scale invasion of Ukraine, to stop a purported genocide. I would also prefer not to recall the hateful words of the deputy chairman of Russia's Security Council, but Russia's agents and counsel were afraid of those words as well. Does Russia truly expect the court to ignore a high-ranking Russian official who states clearly that Russia is acting to punish the perpetrators of genocide under the Genocide Convention? He mentioned the convention by name. He said that this is the reason why the so-called special military operation continues. Russia did not deny that this statement reflects official Russian policy. It could not. This is the official Russian policy. Only in this great hall does Russia's agent ignore it, while its senior leadership continues to repeat it in public sphere. Madam President, members of the court, when it comes to the critical facts of this case, it is Russia's silence that speaks volumes. However, silence would have been preferable to what the court had to listen to on Monday. This is a court of law, not a platform for propaganda. Yet, Russia used its time to tell astonishing lies. Russia disgraced this institution with a conspiracy theory that there were no killings in Bucha. Tragically, the mass summary executions were too real. This is not Ukraine's word against Russia. It is the conclusion of United Nations. Recently, the United Nations Independent International Commission of Inquiry on Ukraine found, and here I quote, "Evidence collected show a widespread pattern of summary execution in areas that Russian armed forces control in 17 localities of the Chernihiv, Kharkiv, Kyiv, and Sumy regions, with the highest number in the Kyiv region, including in the town of Bucha." Russia also blamed Ukraine for the missile attack on the Kramatorsk railway station that killed 59 civilians. The UN Commission disagreed. So did the OSCE. Human Rights Watch also conducted an extensive investigation and concluded, and here I quote, "All evidences point to Russian forces having fired the Donoghue missile with cluster munitions on the Kramatorsk train station." End of quote. Finally, the Russian agent said that, and here I quote, "Ukraine now dares to say the evacuation of children were abductions," end of quote. This is not just what Ukraine says. The International Criminal Court says this too. It understands the forcible deportation of children from their homeland is not an evacuation. It is an international crime. That's why the ICC issued arrest warrants. Russia's whole presentation was built on foundation of similar lies. But we are not here to play Russia's games. We are here to address the court jurisdiction, which is plainly established. Russia appears eager to argue about the facts, so is Ukraine. That's what the marriage stage is for. Russia is angry that 32 states intervened to present their interpretation of the Genocide Convention. Russia may not like those interpretations, but the historic presentation you saw last Wednesday was a really good day for international law. It showed Article 63 of the statute operating as intended. State after state recognized the importance of the Genocide Convention, offered their views on the question of law, not politics, and agreed to be legally bound by your interpretation. To Russia, the fact that so many parties to the Genocide Convention interpreted the same way must be a conspiracy. But there is a simpler explanation. So many states agree with Ukraine's interpretation because it is correct. And so many states intervened because they saw the extraordinary danger of a different interpretation, under which states may callously abuse their solemn obligation to prevent and punish genocide. Madam President, distinguished members of the Court, in the Provisional Measures Order that Russia continues to defy, you recall the Court's essential role in peacefully resolving disputes. 75 years ago, the drafters of the Genocide Convention recognized that role as well. That's why they decided to grant this court jurisdiction that would be as wide as possible. It is in that spirit, mindful of the court's role in the United Nations system and mindful of the true object and purpose of the Genocide Convention, that Ukraine has come to you. We have a dispute with Russia that relates to interpretation, application, and fulfillment of the Genocide Convention. Your jurisdiction to resolve the dispute is clear. Your judgment remains urgently needed. I now have the honor to present Ukraine's final submission. Ukraine respectfully requests the court to dismiss the preliminary objections filed by the Russian Federation on the 3rd of October 2022. Adjudge and declare that the court has jurisdiction to hear the claims presented by Ukraine as set forth in its application and memorial, and that those claims are admissible, and proceed to hear those claims on the merits. This concludes Ukraine's oral pleading and its submissions. On behalf of Ukraine, allow me to thank the Registry for its assistance. I thank the interpreters and the staff of the court for their professionalism during these proceedings. And finally, Madam President, distinguished members of the court, I thank you for your attention in this important matter. We are in your hands.
I thank the co-agent of Ukraine. The court takes note of the final submissions that you have just read out on behalf of your government. This brings us to the end of the hearings on the preliminary objections of the Russian Federation in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation, 32 states intervening. I thank the representatives of the two parties and the intervening states for the assistance they have given to the court through their presentations in the course of these hearings. In accordance with practice, I shall request the agents of the parties and the representatives of the intervening states to remain at the court's disposal to provide any additional information it may require. The court will now retire for deliberation. The agents of the parties and the intervening states will be advised in due course as to the date on which the court will deliver its judgment. As the court has no other business before it today, the sitting is now closed.